So good morning, everyone. Welcome, Sarah, Natalia, Tui, Armando Sierra. I believe that there were some challenges with joining. Oh, there's an echo. Let me just, there we go. So there were some challenges with the Zoom invite. So we are taking care of that. And hopefully everyone will be able to join once we can fix that. So welcome. I believe some of you know me. My name is Paola Fonseca. I am currently the chair for the AAS, Asociación de Abogados de Empresa para Centroamérica. And ever since we started this lovely project, we said, well, ethics and compliance, it's at the heart of what in-house counsels need to execute in their role as a gatekeeper for the whole organization's compliance and keeping that standard that a lot of institutions, either local or internationally, expect from us when we do any type of transaction with them. So thinking about that, we received an amazing invitation from STB Integrity, represented by Sarah. I would let her introduce herself. And said, well, you know, this whole thing about international finance institution and, you know, when they decide to finance something and give some money or do something related to that. So how does that even work, right? We all know that Central America is a region that does receive commonly this type of financing. And sometimes our organization, just because of the way that we do things in Central America, might not talk directly to what is expected. So this webinar, it's exactly tailored in order to highlight the importance, to listen to that voice out of what these institutions expect from us. And the cherry on top of the cake will also get a tool on how to deal with this. We know that a lot of you do listen to this recording. So please remember that you can always email us back in case you have any questions, and we will try to do our best to answer them. For those of you who are live, please just go ahead and post the questions on the chat box. And we'll start with Sarah. I will hand over the host to her. And then we will wrap up with Natalia Callejas. So Natalia is based in Guatemala, and she was actually the bridge to Sarah. So it is thanks to her that we have this lovely opportunity to learn about this. So Natalia will wrap up on the webinar and will also make sure that all your questions get answered. So having said that, and hoping I will not make any mistake, I will return host rights to Sarah, and I will mute myself. So there we go.
Thank you. Thank you so much, both to you, Paola, and to Natalia for having me today for this webinar and for putting this event together. I'm really happy to be here to talk to you about a topic that's the heart of my legal practice and consulting practice, which is integrity, compliance, and IFI finance projects. I'm going to share my screen now, as I have a few slides as part of this presentation. So I hope you can all see my screen. If you can't, please let me know.
Yes, we can.
Good. Perfect. Thank you. So my name is Sarah Talila Bunfor. I am the founder of STB Integrity, a consulting firm specialized in integrity compliance. I am a lawyer. I'm trained both in common law in the US and French law, or civil law in France, rather, specializing in international law and international development. I've spent over a decade working on integrity, ethics, anti-fraud and corruption issues on the investigation side, as well as on the dispute resolution, litigation, arbitration side. And I've spent quite a few years working inside these international financial institutions on integrity issues. So I'll be your guide to integrity compliance in IFI finance projects today. This is what we will cover in the next hour. We've reserved ample time for Q&A, but these are the topics I'd like to cover first before we discuss. We'll take a look at some key concepts, before we identify some of the challenges that integrity compliance can pose in the context of IFI finance projects, we'll look into how to help you and help your companies navigate these challenges. And then we'll look into what happens when there is an investigation into allegations of integrity violations and how you as in-house counsel can help your company best respond to those situations. So first, let's arm ourselves with some key concepts. The first one is IFIs, or international financial institutions. You may have heard the term, you may have also heard multilateral development bank, or MDB. These are equivalent concepts, and they refer to international governmental organizations that lend or grant money to private public parties to finance specific purposes for development objectives. So I would say two of them are primarily present in Central America. That will be the World Bank Group and the Inter-American Development Group. Those would be the main ones. And just for background, you can distinguish between public sector IFIs and private sector IFIs. The World Bank and the IDB do primarily public sector financing, which means that they lend or grant money directly to governments, and then the governments organize procurement processes to sign contracts, allocate tasks under a specific project with different companies. For instance, let's take Panama. The World Bank could lend money to the government of Panama and then the government would organize procurement processes in the context, let's say, of the construction of a dam for electricity production. Then they could cut the project into several contracts for a consultant to design the plans of the project, and then a company to do the works, et cetera, et cetera. And those would be national public procurements, but ultimately be linked to IFI funding. And then these public sector financing IFIs generally have their private arm or private sector division. For the World Bank, it's the International Finance Corporation, or IFC. For the IDB, it's called IDB Invest. And there, the relationship between the IFI and the company is direct. So the IFC or the IDB Invest, they will fund either through lending or through equity investment, the private sector entity. The second concept we'll be talking about today is integrity compliance. And in the context of IFIs, what it means is a set of standards and norms that seek to ensure that IFI funds are used for their intended purposes, which are to serve development objectives, and are not being misused or diverted by the entities that ultimately get those funds. We'll go into the details of what these prohibited practices, these prohibited integrity violations are a little bit later, but just for your information, when we talk about integrity, we talk about mainly fraud and corruption and related practices like theft, misappropriation, collusion, and coercion. Now that we have set the baseline, the key terms that we'll be referring to throughout this webinar, I want to talk about what are the key challenges that you may encounter when your company is dealing with those IFIs and with integrity compliance. Some of the typical compliance issues encountered stem from the following. There tends to be a lack of knowledge of what these integrity compliance requirements are, and that's because they're not exactly the same in IFIs and in national legal frameworks. Even large multinational companies sometimes bid on contracts without realizing where the funding comes from and what that entails in terms of anti-fraud and anti-corruption compliance expectations. Then there's a lack of understanding of the IFI's jurisdiction, because even without a direct contractual relationship, when money is being lent through a government to then conclude contracts with companies, it may seem like that connection is slightly remote. However, anyone receiving IFI funds, however indirectly that is potentially subject to an IFI's jurisdiction for integrity compliance purposes. That means that even if you don't get the contract yourself, but if your company is a subcontractor of another company that gets a contract, that gets direct financing, then you may be exposed to some integrity compliance obligations. I would add to that a lack of alignment between the IFI standards and national law standards. And that's really due to one important fact, is that IFIs, as I mentioned before, are international organizations. They're not governed by national law in any way. They have their own international administrative law corpus, and IFI compliance, integrity compliance standards are part of that. They're administrative in nature and they're international in nature. And that's why they tend to differ in scope mostly. They tend to be wider in scope than strict definitions in national laws that tend to be criminal misconduct. And as you know, in criminal law, we tend to define the behaviors that are prohibited in a very strict manner for due process reasons. So if you combine all of this together, you see how there is a risk for unintentional non-compliance. And the reason why that's important is because the consequences of non-compliance can be quite devastating for a company's business. And I want to take an example to illustrate this. If we take the example of a company in the construction sector that perhaps has a local country representative acting, let's say in Guatemala, there's the Inter-American Development Bank that lent $50 million or $400 million for a multitude of projects to the government. And let's say it includes the construction of road infrastructure. And you take that one company that has its country representative that makes a mistake. They pay an agent. They don't do a lot of due diligence on that local agent to help them bid for the contract, for the construction contract. And that agent uses part of the money to pay, let's say, for gifts to public officials, perhaps invite them to lavish outings. And these public officials have a role in the award of the contracts. Now you can see how that might fall under the definition of corruption. It could be a small sum, it could be very small gifts, it could have not impacted the ultimate decision. But still, even if it doesn't involve the management of the company, that exposes the company to integrity compliance sanctions under the IDB framework. And to give you an idea, this is a table of the type of sanctions that may result in this type of cases. However small, any sort of integrity violation, like fraud and corruption, will expose the company to a baseline sanction of 3-year debarment. Debarment is an exclusion from the possibility to receive IFI funds. So in our example, the company, if in the event that there is evidence of corruption, would be excluded for a duration of 3 years from participating in other bidding processes and from receiving fundings from the IDB. Now, you see that there are financial sanctions and non-financial sanctions. So there is a range, and I'll talk later about what factors may impact which sanction applies at the end of the day. What we need to know is that baseline sanction is a 3-year debarment, and there's no automatic end to that debarment. It's 3 years minimum. But in order to get released from sanction, the company needs to provide proof that it has complied with some improvements requirements for its internal controls, its internal policies, and that is monitored by an independent integrity compliance officer. So it's quite a demanding situation, a demanding process. And what's important to know is that it doesn't end right there. If there is an issue in an IDB finance project and there is a sanction, it doesn't limit itself to the IDB. And that's where I believe it's particularly important for in-house counsels to really understand the full risk of repercussions of this type of integrity violations. It doesn't stop at the IDB, and that's for 3 reasons. First, there is a cross-debarment agreement between the 5 main IFIs across the globe. So that includes the IDB and the World Bank Group. And if your company is debarred for more than 1 year by the IDB, automatically the 4 other IFIs will apply the same debarment, which means that your company is suddenly also deprived of opportunities to get business with the World Bank, the IFC, and the other IFIs. So that's the first extension of the sanction scope. The second reason is that the IFI sanctions lists are public, and they tend to be part of all the other sanctions lists that are checked by many financial institutions and many companies when doing due diligence before a transaction. So that could also affect the potential for your company to get business or to get financing from private capital banks. And the third additional sanction risk beyond being debarred by one IFI is that many of these IFIs, especially in the case of corruption, will have a duty to refer the case, to refer evidence of criminal conduct to competent national authorities, which would generally be law enforcement authorities of the country where the misconduct happened, and if that's a different country, the country of registration of the company and the individuals involved. So you see how just this one mistake in an isolated IDB finance project can have further consequences and even lead to potentially criminal proceedings and sanctions. All of this combined, that compounds as well the reputational risk for the company. Before I move forward, because I do not see the chat on my screen, are there any questions that I can address at this stage?
If I may, Sarah, I do have a couple of questions. One is, from what you have seen in your experience, who or how would the IFIs would get notice of non-compliance? That would be a first one. Who typically tips off? Is it the sort of a receiving end of the funding company, or would it be typically a third party? That's one. And the second one would be, have there been instances in your experience where companies have said, well, what is the IFI's jurisdiction in terms of having the powers to enforce said sanctions?
Fantastic questions. So the first one, I'll start with that. Who may be reporting? How does the IFI find out about potential integrity compliance violations? So most of them have a reporting mechanism that's generally going to be advertised on their website. It might be even advertised in the countries where they operate, especially when the projects might impact local communities. There are grievance mechanisms, there are reporting mechanisms in place through hotlines, online forms to fill out, and there's an obligation within each IFIs for staff that work for the organization. If they hear of anything, they have an obligation to report it back to, let's call it the integrity unit. So that's going to be the department inside the IFI that is in charge of receiving these complaints or reports, examining them and deciding whether to investigate, and then later on deciding whether to seek sanctions against involved parties. Those reports in practice can come from a great variety of parties. I've seen it come, especially in construction projects. Local communities tend to be quite involved, or they know about the project. And so we've seen a lot of complaints come from people who just live in the area of the project and hear about some issues, perhaps of corruption, how the project, how a company obtained a contract through corruption. We've also seen many cases come from the teams either at the government level that receive funding or at the IFI level that review procurement documents, so the bids that are submitted by companies. For fraud cases, that often comes, the allegations often come from them that see documents firsthand. Interestingly, I've seen a whole lot of cases coming from competitors. So that's especially the case for allegations around the award of contracts in public sector financing. And you'll see a lot of competing bidders that didn't get the contract and now will bring out a claim against one of their competitors that was awarded the contract. So that's a great variety of sources. I hope that answers your question, but I'm happy to dive into more detail a little bit later. And Natalia, would you mind reminding me the second question?
Sure. Have you encountered instances by which a company, when they're being approached by the IFIs on the notices that they received for non-compliance, where they have questioned sort of like the powers of the IFIs to enforce these or the sanctions, basically?
Great. So jurisdiction will be important, I would say, primarily at the investigation stage. There will be an opportunity to challenge jurisdiction in the adjudicative phase, because there is a whole litigation process that may take place. But really, and I'll touch upon that a little bit later, but let me just at least give some pointers now. The essential basis for the jurisdiction of the IFI lie in the contractual agreements, either the direct agreement with the company in the event of IFC or IDB Invest agreements, or in the financing agreement between the World Bank and the IDB and the member state that is receiving funding and conducting the procurement processes. This is where you will see exactly what clauses are included. These clauses should always be included normally in procurement documents, but they're not always. And this is what IFIs will rely on. There is typically an audit and inspection clause. This is what allows really the investigation to take place and the IFI to get access to your company's books and records. And it's very important that you as in-house counsel really get access to that clause. And if it's not provided by the IFI, that you request the exact clause, because depending on how it's phrased, it might actually greatly limit the scope of the IFI's jurisdiction and investigative powers. Another point that's important is that public officials are not covered by IFI's jurisdiction, and that is one of the biggest criticisms, but it was a bit the result of a compromise that had to be made with all the states financing these IFIs. So government officials are not covered unless they operate on some form of contract with the IFI. If there's no other questions so far, I'll move on to the second part, which is how to navigate these challenges that we've just identified. And first, it's time to look at whether these key integrity standards, what are the main prohibited practices? I've mentioned fraud and corruption. These are the two main categories of cases that we see in IFIs, across IFIs. These are really the statistically the most prevalent ones. Fraud being number one. Fraud is defined in an extremely wide way. I put the definition on the screen and you'll get the slides afterwards, so I won't read. But what's important is that any sort of misrepresentation even if not intentional, even if just a reckless mistake, so long as it misleads the authorities making a decision, that's enough to constitute fraud. So for instance, a mistake omitting to declare that there was a potential conflict of interest, even if it was an actual conflict of interest, or any mistake in stating the annual turnover of the company in a bid, even if it was not intentional, that may be enough to constitute fraud. So you see how the bar is quite low compared to national criminal laws. Corruption is also wide in scope because it includes the offer and the supply and the demand side of corruption on both ends. It's both offering, but it's also receiving. And it covers trading in influence, which is not always criminalized in national laws, although many international conventions encourage that. So it's called corruption, but really it covers a whole set of criminal misconduct that we're generally familiar with. Then we have collusion. Collusion would be the third most prevalent category, and it covers anti-competitive practices. IFIs have that responsibility to all the states that finance their budgets to account for every dollar that is spent. And the best way to use their money and their budget efficiently is to make sure they have the lowest prices on every contract. And the way to do that is through competition. So there is a high importance placed by IFIs on making sure all procurement processes are competitive, and collusion refers to any sort of arrangement between bidders or between a bidder and the authority, awarding contract or paying invoices, etc. Any sort of arrangement that would achieve an improper purpose and essentially rape competition or facilitate the diversion of funds, that would be considered collusion. The other category that I will mention that is not in existence in all IFIs, but it is at the IDB, is misappropriation and theft. So that's really just any sort of diversion of funds for improper or unauthorized purpose. Most IFIs deal with that through the lens of fraud, because in order to misappropriate funds, oftentimes some form of misrepresentation or forgery is involved. But there are cases where they're not. And so that's why the IDB has a separate definition and prohibited practice. And finally, I'll mention it briefly, it's coercion. It's extremely rare in IFI case law. We rarely see these cases. As an investigator and litigator at the World Bank, I've actually never come across such a case. But you have to know that it exists, and it's really about threats or harm caused in order to obtain an advantage. Please feel free to interrupt me, Natalia, if there are any questions on that. Otherwise, I'll move on to how to maintain compliance throughout the project life cycles, knowing these prohibited practices. We have 3 stages. So if we talk about procurement or bidding processes or contracting directly with an IFI, this is where we see most cases happen, and you can understand why. There's lots of money flows coming into a country, a particular sector, and so there's high incentives on all sides to get contracts, and that means a heightened risk of integrity violations. That's why there is a premium on transparency on the part of IFIs, and any misrepresentation can easily become a fraud. So I would strongly advise in favor of really spreading the word in your companies, and especially in the teams that are preparing those bids, to be very mindful to have, the 4I principles, so that they double check all the information and they make sure there's no unfortunate mistakes that could be perceived as fraud. And I would also make a note of agents, because that's an issue that I've seen come up many, many times. Agents are used very commonly across the globe by companies, whether they have a local presence or not. just to bring business opportunities to their attention or to help get some background information to prepare the bid. It's not prohibited per se in IFIs. You may have been asked as in-house counsel to advise on some agent contracts. And so it's good to know that it's not prohibited. That being said, the mere omission to this, the mere failure to disclose that an agent was used or how much was paid to the agent constitutes fraud. So again, very important to be transparent. At the implementation stage, attention should really be on potential red flags and on having good reporting inside the company so that immediate mitigation and corrective action can be taken. I would really draw your attention to the fact that your company may very well be responsible for misconducts that takes place down the supply chain, for from partners, suppliers, subcontractors, and you see that really across national legislation as well. Natalia, I see you have your hand raised.
Yes, I would like to understand from your experience, what's the perception of the IFIs on self-reporting any sort of a potential non-compliance issue?
Well, that was actually my next point. So perfect timing for that question. That happens generally, at the end of a project, you may discover that something fell through the cracks, but it could also happen at the implementation stage. If the company becomes aware of a potential integrity violation, there may be an opportunity to self-disclose. Many IFIs have a voluntary disclosure program, which is a concept that really was borrowed from the US system and FCPA regulations. It exists. I'll be honest, it's not often used, and that's because it is welcomed by IFIs, but the conditions are quite stringent. So many companies are hesitant to come forward because they feel it's going to be very costly in legal fees, and they don't feel sufficiently secure in the fact that they will avoid sanction. But these exist. So I would say, especially if there's a serious case that comes to your attention, I would most importantly seek specialist advice, not from your typical white-collar crime lawyer, but really from someone who's familiar with IFIs and with their voluntary disclosure program, the conditions that apply, the practice that exists, to help you determine whether that is in your company's best interest or whether it's actually better to stay quiet and not disclose. So it exists. It's not used often enough, even though it offers quite a few advantages and can help your company avoid sanctions altogether. So before I move on really to the investigation phase, which I think is super important, I just want to share some basic resources if you want to familiarize yourself a little bit more with IFI integrity compliance frameworks. You're going to look at each of them. They have a legal framework, and the specifics about their integrity compliance requirements, their sanctioning system, their investigative powers, that's going to be, I mentioned before, in the contractual agreements, but also in their procurement rules that govern procurements they finance, and in their integrity or anti-corruption guidelines. There are 5 IFIs that tend to work together quite a bit to issue non-binding guidance for companies that work and that engage in transactions with IFIs or under IFI finance projects. And the latest one I want to point out were issued in March 2023. They're incredibly helpful for integrity compliance programs because it gives you an idea of the general principles that IFIs will look at when they look at your integrity compliance program. And I'll explain a little bit why that's important. But it can give you a few pointers as to what they expect to see from your companies. And finally, may be familiar with collective action initiatives, which can be extremely useful, a great source of information, advice, and tools to deal with fraud and corruption risk in your local market or in a particular sector. Again, I don't think we have a lot of time to get into that, but I did want to bring it to your attention as a potential resource to help you navigate integrity compliance risks. Are there any questions so far before I move on to investigations? All right, I'll take it as a no. So what happens if suddenly you discover that your company is under investigation by an IFI for potential integrity violation? I just want to walk you through the process very quickly so you have a bird's eye view of what happens in the IFI. You have the investigative phase that is led by an integrity unit inside the IFI. And the moment you'll find out about the investigation is when you receive a letter that is often called an audit letter or request for information. The integrity unit will be asking to get access basically to your books and records, to the key people in your organization that worked on the contract, the project. You may not be notified of the allegations under investigation or in a very broad way. So that doesn't give you a lot to go with, but I'll explain how you deal with that. Later on in the investigation, if there is evidence of integrity violation involving your company, this is when you receive a notice of allegations with all the detail, and that's your first real opportunity to present your case in writing. Finally, the integrity unit has discretion to decide whether to settle or whether to initiate litigation proceedings seeking sanctions. If there's no settlement, we go to the adjudicative phase. That is a 2-level process with a right to appeal. And finally, if there's a sanction, I already mentioned earlier, all the conditions to be released from sanctions are monitored by an integrity compliance office that is independent from the integrity unit. The first reflex I want you to keep in mind if you ever are under investigation by an IFI is to conduct an internal review ASAP. In order to do that, I really advise having a policy throughout the company so that anyone who receives a letter from an IFI immediately brings it to your attention at the legal office. I've seen too many cases where a company fails to respond, does not cooperate, and does not use the opportunities that it has to present its case because the letter got lost somewhere. These letters are not sent to CEOs all the time. They're sent to the person who signed the bid or the contract. And that's not always a high-level executive. So very important to have that information shared throughout the company. Then when you get the letter, run your mini investigation, gather all the documents, speak to the key people, and as quickly as possible, identify potential red flags or issues to evaluate the risk. And I would really advise outside counsel for serious cases, especially. You can craft a strategy that is most adapted to your situation. The second reflex to have is to really be proactive to mitigate the potential sanction at the end of the investigation. I've said it before, sanctions are affected by a multitude of factors. They're both aggravating factors and mitigating factors. So you start from that 3-year debarment baseline, and your goal really is to not go to the adjudicative phase. Your goal is to either avoid any sanction, or if there is actual evidence of integrity violation, your goal is to get a settlement. And in order to do that, in order to get a good settlement, you want to mitigate your situation. Aggravating factors, I won't go into them in detail because as in-house counsel, you have little to no control over them. They really have to do with the nature of the misconduct at issue. But where you have immense impact is how you help your company react during the investigation, because that is where you can get the most mitigation. I'm going to show you how. There are 2 categories of actions you can take. Together, they can help you get up to 83% reduction. And that's a figure that I'm not inventing. That's a figure that comes from the harmonized guidelines on sanctions from 5 of the major IFIs, including the World Bank and the IDB Group. With corrective actions, you can get up to 50% reduction. With cooperation, up to 33% reduction in your sanction. That means that from the 3-year debarment baseline sanction, you can either go down to non-debarment, either conditional non-debarment or reprimand, or you can simply get to a much shorter debarment and go under that 1-year threshold, meaning that you would only get debarred by one IFI and not by the whole group. So you can see really the advantage in considering those mitigating factors. Corrective actions, they're really for. If misconduct is underway and you discover it while it's still happening, do whatever it takes to stop it. That will get you significant mitigation credit. If any funds were illegitimately obtained through that misconduct, consider a way to restitute the funds, to calculate how much was at stake and restituting the funds to the IFI. If you can identify the individuals responsible within your company, taking internal action, subject of course to applicable labor laws and due process requirements, but taking internal action is probably one of the most important corrective actions you can take, even if the misconduct has already happened and there's nothing you can do about it anymore. Finally, the last one is having a good compliance program. Already having one in place, that gets you mitigating credit. And if after learning of the integrity violation, or after seeing evidence, you draw lessons learned, you can identify this happened because of a gap in our compliance programs, updating, taking measures to change your internal controls and policies, that gets you additional mitigation credit. So you see, these are all measures that are really within your powers, even if something did happen and unfortunately exposes the company. On the cooperation side, simply disclosing facts and evidence promptly when you're asked for it during the investigation, when the integrity unit asks for documents, wants to interview people, just making those available, that gets you credit. Admitting responsibility when faced with undisputable facts, that gets you mitigation credit. Conducting a truly independent internal investigation, especially in the event of serious violation, like serious corruption schemes, etc., that can go a long way. But it truly needs to be independent to be considered as an internal investigation warranting mitigation. And finally, if you have little business with IFIs, or at least if you think you really need the mitigation credits and it wouldn't affect dramatically your business, you can consider restraining voluntarily from bidding on that IFI on other projects funded by this specific IFI. But in any case, I would really, really strongly advise against obstructing an IFI investigation. If there's one takeaway, that's what it is today, because you have much more to lose by obstructing than by cooperating. Cooperating gets you potential mitigation credit. Obstructing, on the other end, is its own prohibited practice. So that means that just by obstructing, you might expose your company to a 3-year debarment sanction. And that doesn't mean that there won't be evidence, found of fraud or corruption. So potentially you're even doubling that sanction. Natalia, please go ahead.
A brief question on obstruction. What actions could be considered as obstruction? I mean, you don't necessarily have to not only restrict access to information, but could there be some other actions?
Sure. So I would say the most obvious ones would be destruction of evidence. I've seen that happen. Destroying evidence, doctoring evidence, altering records before the investigators show up to your company's offices. If that's detected, that's automatic obstruction, almost automatic. I think where there's a little bit more of a gray area, if you're not providing all that is requested. There's a bit of a gray area here. If there's complete refusal to grant access, we go straight to obstruction. But if there are some more subtle cases where in appearance, the company says it's willing to cooperate, but it's delaying constantly. And so the IFI has to move, its plans all the time, is wasting a lot of time, is wasting resources, and eventually doesn't really get access to the core of what it needs, that may be considered obstruction. So the standard, again, I think what needs to be remembered is that the standard is quite low for integrity misconduct to be found, including for obstruction. And the standard of proof is not the criminal one. We're not talking about beyond a reasonable doubt. It's just more probable than not. So if you are under investigation, I would think of it as when the tax office knocks on your company's door, you're thinking, oh, there might be smoke already. That's why they're using resources to come visit us and look at our books and records. It's because there's smoke, so they think there might be fire. And that's the same thing for IFI investigations. So I want to keep a few minutes again for Q&A. So just very briefly on long-term benefits, I think the main one is that investigation may be an opportunity to identify gaps in compliance programs, risks that may not have been seen before or may have been misevaluated. So that's a great opportunity to beef up a compliance program. I'm going to leave you with just these few things in conclusion: to liaise with your compliance team to ensure knowledge of IFI integrity requirements, have a policy to ensure your legal department receives notice of any investigation that happens or audit, conduct your own internal review as soon as possible, seek specialist advice to craft a strategy, and consider cooperating and taking corrective action in order to reduce the risk of sanctions, and encourage the integrity unit to consider settling and getting a reduced sanction. I'll share the slides afterwards, so you'll have a few resources here, but now I really want to leave it to you to answer questions that you may have. Thank you very much for listening.
Thank you so much, Sara. I think it has been very interesting. We do have some questions. Armando is asking, how do you get into investigative roles for an IFI?
Oh, I'm so glad you asked. That's actually an activity that I do on the side that I love. We can talk about it on the side. Feel free to send me an email. It's here on the screen. But every Friday, if you follow me on LinkedIn, I post a job board. So it's a whole list of jobs that are investigative jobs or litigation jobs as well, related to integrity in international organizations, including IFIs. And I would say it's a difficult world to get into. Oftentimes you have to go through consultancies, and it's a lot of networking, but it's very rewarding, and I can only advise you to consider it at some point. But I think perhaps to go more into detail, I would say email me and we can schedule a call.
Great. And Arturo is also asking us, he's saying a very good presentation, and a question: in your experience, do you have a list of countries where the doing business is hard or difficult in respect to corruption?
I don't know if it's an unpopular opinion, but I would say really every country. I have not come across one that does not present its own challenges. The difficulty, I would say, is if you go into a new market, into a new country, is getting as much information as you can about what are the specific challenges in that market. The risks are not the same, and I would say the practices are not the same. So even in terms of corruption, if you investigated in Francophone West Africa or in Central America, you won't find the same type of schemes. You won't find the same type of practices from public officials as well. How do they solicit money? Or what type of advantages they solicit? How do they put pressure on companies? All of that. These are very linked to the economic context, to the incentives that exist, to cultural norms, and that's why I believe you really need local knowledge to be able to assess the risk and address them. But yeah, if you know of a country where it's not a problem, please let me know.
Thank you, Sara. And Paola was asking, can you share some tips for compliance in small organizations without a large compliance team?
Yes, absolutely. So first, I will again refer to the Business Integrity Program guidelines by the IFIs, because they're actually designed for companies of all sizes. Even small and medium enterprises might find information that's helpful. I would also advise on those collective actions that exist, because that's a great way for small and medium enterprises to get lessons learned from bigger enterprises, get their advice, and see what they can take or not. And then I would say one of the big advantages of small organizations is that it's easier to conduct training. You don't have to deal with hundreds and hundreds, if not thousands, of employees that I think we know, each employee is a potential source of risk. So in smaller companies, I think an emphasis on training and really sharing that knowledge and giving tools directly to the people that deal with the day-to-day operations of the company, that is the best tool that exists.
Great. Well, I think that's the questions that we have for today. I really want to thank you, Sara, for the opportunity to have you here with our in-house counsel group. And thank you, Paola, for organizing this. It has been quite an enriching conversation. I believe we have a few points I'd like to highlight. The first of those being compliance is not the same when dealing with IFIs. I think that's an issue to understand and to highlight, that dealing with IFIs is a completely different matter than dealing with your normal local compliance issues. Also, the correct understanding of the different documents that make up our commitments to IFIs, and also paying attention to our different supply chain vendors or agents that we use when performing works, and with either financing from IFIs or in works that have been awarded to us. Another point I would like to highlight that I believe is important is the being proactive when it comes to measuring the impact of the actions that the company takes on a day-to-day basis, and understanding the alignment of said actions with the different commitments that have been taken with the IFIs, and also a collaborative approach when it comes to investigations and potential non-compliance issues, with a very again, proactive approach on mitigating any risk factors that could come out of this, and of course an attitude of collaboration towards the different officers that would be involved in an investigation. This has been, I think this is a first conversation, something that is new for us in the region, having a specialized IFI conversation on compliance. We are still in many of our countries in creating the different legal regimes and understanding how to tackle corruption. And I think learning from the guidelines and standards from the IFIs is of great benefit to all. And this conversation, Sara, thank you very much for taking the time to speak to us. And hopefully, if any of you have any questions, you can email Sara directly or contact us, and hopefully we can move the ball forward and have this conversation again sometime soon. Thank you, Paola. Thank you, Sara, and thank you everyone for joining. And feel free to reach out if you have any questions.
Yeah, I think am I unmuted?
No. Yeah, you're.
We hear you.
Okay, yeah, I cannot turn on my video, but really, thank you so much, Sara. Honestly, I had never heard such a detailed approach to what this entails regarding compliance. All of you listening to the recording, if you also feel that it's material that you can share with someone outside the in-house counsel community, please go ahead and make that bridge, right? sort of like let people run through that highway, because right now we're giving it a sort of like legal or compliance approach. But we all know that we're not the first gatekeepers of this, right? It's usually up to the business or the project managers to understand and to embed all of this information into the actual project idea or project design. So go ahead and do that. And again, thank you very much, Sarah and Natalia.
Thank you. Thank you to both of you and to everyone who attended.
Bye-bye.
Bye, everyone.